The United States Supreme Court. A silence so deep you could hear every breath. The echo of footsteps fades between towering marble columns. Denzel Washington, dressed in a perfectly tailored navy suit, steps to the lectern. He is not an actor right now, not a Hollywood icon. Today, he is an attorney standing before the 9 most powerful judges in the nation for the very first time. His eyes are cold, focused. In front of him, a case that could reshape the law and change the lives of thousands. Henderson versus the Department of Justice. It's about civil forfeiture without criminal charges, about how, in struggling neighborhoods, the government seizes buildings, businesses, and homes based on a mere hint of illegal activity, even when the owners are completely innocent. Washington begins in a steady voice. Mr. Chief Justice, and may it please the court. But before he can finish his opening, Chief Justice John Roberts interrupts him. Roberts's tone is cold, laced with condescension. Mr. Washington, given your previous background, I find it difficult to believe you fully understand the constitutional implications of your position. The words cut through the air like a blade. The courtroom freezes. Attorneys in the front rows stop scribbling notes. Reporters pause mid-sentence. Law clerks glance at each other, eyebrows raised. This isn't just a question, it's a public attempt to diminish him. The unspoken message, you're an actor. You don't belong here. Roberts presses on. Your brief seems to overlook 2 centuries of settled civil forfeiture doctrine. It sounds like a verdict before the trial has even begun. A declaration that this celebrity has stepped into waters far too deep. A faint smirk flickers on a few faces in the gallery. Some are waiting for him to falter, to stumble over his words, to lose his composure. For most, this would be the breaking point. But not for Washington. He doesn't move, doesn't look away. His voice stays calm, but there's steel in it. Mr. Chief Justice, I believe my position is entirely consistent with the historical understanding of the Fifth Amendment, as articulated by Justice Thomas in his concurrence in Timms versus Indiana. If you're willing, we can examine the text and the historical sources together. He places a worn copy of the Constitution on the lectern, along with several centuries-old legal volumes. It's not just a statement. It's a challenge. He's not here to apologize. He's here to fight on the battlefield of ideas. Roberts's eyebrow rises slightly. He hadn't expected the movie star to bring original sources to the podium and speak with the poise of a seasoned litigator. Still, he doesn't relent. Instead, he decides to tighten the grip. You've overlooked the 1827 case of the Palmyra, which clearly expanded the government's forfeiture powers. It's a trap. Many attorneys have stumbled here, losing credibility before they even find their footing. Washington doesn't flinch. With respect, Mr. Chief Justice, I have not overlooked that case. On page 23 of my brief, I address Justice Story's opinion in detail. He flips directly to the page without even glancing down for reference. But the Palmyra was fundamentally a maritime case involving piracy, where the vessel itself was treated as the offender. That legal fiction made sense in admiralty cases, where personal jurisdiction was often impossible. But in over 27 civil forfeiture cases decided between 1789 and 1850, not one permitted the kind of land-based seizure from innocent owners we see in Henderson. The room grows still. Some begin to realize this isn't a sideshow. This is the opening volley in an intellectual duel that could turn the tide of the entire case. The Chief Justice's attempt to pin Denzel Washington into a corner has just failed. What was supposed to be a polite dismantling of a celebrity's argument is beginning to take an unexpected turn. The courtroom senses it. You can feel the shift in the air. The kind of tension that comes when the underdog refuses to play the role he's been assigned. Washington doesn't just answer Roberts' trap, he dismantles it with surgical precision. The Palmyra, a cornerstone in forfeiture law, has been invoked countless times as a blanket justification for government seizures. But Washington's rebuttal slices straight to the core. It's a maritime case about piracy, rooted in a legal fiction that doesn't fit domestic property seizures. It's not an opinion. It's history, sourced, documented, undeniable. And now the gallery, filled with attorneys, clerks, journalists, is leaning in. They were expecting scripted sound bites, maybe a dramatic pause for effect. Instead, they're getting footnotes brought to life, case law recited from memory, and a calm, unflinching delivery that makes even the seasoned justices take notice. Chief Justice Roberts shifts in his chair. It's subtle, but everyone sees it. A sign that his first offensive has met resistance. He pivots. If historical framing isn't enough to shake Washington, maybe the breadth of precedent will. Mr. Washington, your brief argues that civil forfeiture was historically limited to admiralty and customs cases. But you've ignored 2 centuries of practice that prove otherwise. Washington meets the challenge head on. On the contrary, Mr. Chief Justice, I've traced every relevant case decided by this court between 1789 and 1850. All 27, every single one involved maritime seizures, customs violations, or piracy. Not one approved the kind of property seizure at issue here. The murmurs start. It's one thing to make a bold claim. It's another to have the receipts, all of them, ready to deploy without missing a beat. Justice Samuel Alito leans forward, his tone probing but measured. That's an interesting historical observation, Mr. Washington. But how do you account for our more recent precedents, like Bennis versus Michigan? It's a test, an invitation to wade into dangerous waters. Challenging a modern Supreme Court precedent is no small matter. But Washington doesn't hesitate. Justice Alito, I believe Bennis was wrongly decided. Gasps ripple through the gallery, directly questioning the court's own precedent in this chamber to the faces of the justices who guard it. It's as bold as it gets. But Washington isn't reckless. He cites Justice Thomas and Justice Ginsburg, polar opposites in judicial philosophy, who both dissented in Bennis. He points out the doctrinal tension that decision created and how Henderson offers the perfect opportunity to resolve it. The pace quickens. Justice Brett Kavanaugh joins in. Your historical argument is compelling, Mr. Washington, but there's a practical side. Civil forfeiture is an important tool for law enforcement. Are you suggesting we eliminate it entirely? Washington's reply is crisp, almost surgical. Not at all, Justice Kavanaugh. I'm suggesting we restore it to its original boundaries. Admiralty, customs, and situations where the owner cannot be brought into court. But when the government can prosecute and chooses not to, yet still seizes property, the Constitution demands higher safeguards. And just like that, the ground tilts again. This isn't the performance of a man in over his head. It's the precision strike of someone who has mapped the battlefield long before the first shot was fired. The justices exchange glances. They came prepared to question him. Now, they are beginning to question the doctrine itself. By now, what began as a condescending cross-examination has turned into something else entirely. The Chief Justice's early jabs have failed to land. The so-called celebrity advocate has not only held his ground, he's forcing the court to engage with him on equal footing. One by one, the justices step into the exchange. Justice Elena Kagan, her tone sharper now, cuts in. Mr. Washington, your historical research is impressive. Did you work with a team of legal historians for this? It's a question that could have gone either way. An acknowledgement of his work, but also a chance to expose him if his knowledge is secondhand. Washington doesn't flinch. No, Justice Kagan, while I've studied the scholarship, I conducted the primary research myself. I traced the original cases, examined the archival documents. That was during my years at Howard University School of Law, and in the time since. The revelation lands with force. Until this moment, many in the room thought the law degree was a publicity stunt. Now they learn that the man at the podium spent years studying constitutional history in the quiet hours between film sets, diving into the dusty records most attorneys will never touch. The dynamic shifts again. Justice Sonia Sotomayor seizes the moment, redirecting the conversation to the case at hand. Mr. Washington, applying your framework, how would you judge the government's seizure of the Henderson Community Center? Washington turns toward her, his voice steady. Justice Sotomayor, under the original understanding I've outlined, that seizure fails on multiple grounds. First, a single drug transaction on a public sidewalk creates at most a tenuous connection to the property. Second, the government has made no attempt to prove the owners knew about illegal activity. And third, the taking is grossly disproportionate to any harm caused. He pauses, lets the silence do the work, then delivers the blow. Most fundamentally, this seizure violates the Fifth Amendment's public use requirement. Civil forfeiture that funnels property into general government revenue, instead of remedying a specific harm, cannot meet the public use test as the founders understood it. The justices are listening now, really listening. Several take notes. Court officers discreetly extend Washington's time, a courtesy rarely granted, and only when the bench is deeply engaged. Even Chief Justice Roberts, who began this session with a barb aimed squarely at Washington's credibility, is leaning forward, hands clasped. His expression is different now. Not smug, not skeptical, but attentive. Justice Amy Coney Barrett joins the fray. Mr. Washington, your brief makes an interesting textual argument about the Due Process Clause and the Takings Clause being more intertwined than scholars usually suggest. Could you elaborate? Washington's response is deliberate, precise. Justice Barrett, the historical evidence shows the framers saw property protections holistically. James Madison, the drafter of both clauses, wrote that seizing a citizen's property without due process and without public purpose was a double violence against the most sacred right in a just society. From his folder, he produces a photocopy of Madison's handwritten letter to Thomas Jefferson, an original source not cited in any previous forfeiture case. The gesture lands like a hammer. It's not just knowledge, it's proof. And now, in a courtroom where moments earlier he was treated like an outsider, Denzel Washington stands not as an actor, not as a guest, but as a peer, steering the conversation at the highest judicial level in the nation. By now, the entire courtroom knows they're not watching a token celebrity appearance. They're witnessing a constitutional duel, one where the unexpected challenger is steadily gaining the upper hand. Chief Justice Roberts, having shed the sharp edge of his earlier tone, leans forward with genuine engagement. Mr. Washington, if we were to adopt your historical framework, What specific test would you propose for evaluating civil forfeitures going forward? It's a remarkable shift. This is no longer the kind of question meant to trip someone up. This is an invitation, the sort of opportunity given only to advocates the court respects enough to shape doctrine. Washington doesn't hesitate. He raises three fingers, each word measured, deliberate. First, the government must establish a substantial connection between the property and criminal activity, not the tenuous link claimed here. Second, when the owner is subject to the court's jurisdiction, due process requires either a criminal conviction or proof by clear and convincing evidence that the owner knowingly consented to the illegal use. Third, the forfeiture must meet the public use requirement by addressing a specific harm, rather than simply generating revenue. He lowers his hand and lets the silence linger. The test is clean, logical, rooted in history, but practical enough for modern courts to apply. It's the kind of structure that could live on in casebooks for decades. Justice Clarence Thomas, usually silent during oral arguments, finally speaks. The shift in the room is almost physical. Reporters lean forward, pens ready. Mr. Washington, your approach is persuasive, but tell me, would it require us to overrule Bennis versus Michigan? It's a question at the very heart of stare decisis. The court's reluctance to overturn precedent without compelling reason. Washington answers without missing a beat. Justice Thomas, while I believe Bennis was wrongly decided, you need not overturn it to resolve this case. Bennis involved a vehicle directly used in criminal activity. Henderson involves real property with only the faintest connection to alleged wrongdoing. The court can distinguish the cases while reaffirming constitutional limits. It's a masterstroke, advancing his argument while respecting the court's institutional caution. Roberts listens, then asks what might be his final question. Mr. Washington, have you considered the practical implications? If we accept your view, many existing forfeitures could be challenged. The reliance interests are significant. Washington nods. He's ready. From his folder, he produces a neatly prepared chart. Yes, Mr. Chief Justice, my analysis of the Department of Justice's data shows that roughly 87% of current forfeitures would remain untouched, those involving unclaimed property, customs violations, or cases tied to criminal convictions. Only the 13% that most offend our constitutional traditions, seizures from innocent owners without charges, would be affected. The numbers are precise. The framing is surgical. It's not an abstract theory anymore. It's a roadmap for reform. The atmosphere in the courtroom is transformed. This is no longer about a celebrity out of his depth. It's about the court grappling with whether the man at the lectern has just handed them the key to correcting decades of drift in forfeiture law. Even Robert's body language has changed completely. The man who once questioned Washington's very right to stand here is now leaning forward, listening intently, his earlier skepticism replaced by something else. Respect. The duel is no longer about survival. It's about persuasion. And Washington is winning. When Washington finally steps back from the lectern, something extraordinary happens. There's no abrupt interruption from the Chief Justice announcing that his time has expired. Instead, the room holds still, a rare, almost reverent pause. Several justices are still writing, their pens scratching across notepads. Others lean back in their chairs, processing what they've just heard. Chief Justice Roberts breaks the silence. His voice is markedly different now. The condescension of the opening moments is gone. Thank you, Mr. Washington. Your argument has been exceptionally informative. The subtext is unmistakable. What began as an attempt to expose a celebrity's lack of substance has turned into a public acknowledgement of his depth, preparation, and mastery of the law. The government's attorney rises next, visibly unsettled. The dynamic of the case has shifted. The burden is no longer on Washington to prove himself. It's on the government to defend a doctrine that suddenly looks shaky in the light of originalist history, constitutional text, and cold, hard data. 6 weeks later, the Supreme Court delivers its opinion in Henderson versus Department of Justice. In a 7-2 decision, they rule for the petitioners, adopting much of Washington's three-part test. The majority opinion, authored by none other than Chief Justice Roberts, quotes Washington's oral argument 4 times, even citing his historical research in a footnote commending exceptionally thorough preparation. Justice Thomas writes a concurrence urging the court to go even further, while Justice Sotomayor highlights the disproportionate impact of civil forfeiture on disadvantaged communities, echoing statistics Washington presented. The opinion sends immediate shockwaves through the legal world. Within months, multiple states reformed their forfeiture laws to comply with the new constitutional limits. Millions of dollars worth of property is returned to community centers, churches, and small businesses wrongfully seized under the old standards. Law enforcement agencies shift their focus, targeting forfeitures tied directly to criminal convictions rather than speculative claims. For Washington, the victory opens a new chapter. He establishes the Washington Justice Initiative, a nonprofit offering legal representation to communities hit hardest by abusive forfeiture practices. Law schools invite him to lecture on constitutional history. Applications from underrepresented minority students spike nationwide, many citing his example as the reason they decided to pursue law. 6 months after the decision, Washington and Roberts appear together at a Georgetown law forum. The exchange between them is cordial, even warm, with occasional humor about their first encounter in court. Roberts admits publicly, "Mr. Washington taught me an important lesson that day, never to confuse celebrity with capability." Washington responds with dignity. The beauty of our legal system when it works as intended is that arguments stand or fall on their merits, not on who makes them. Clips of their conversation spread online, joining the now legendary footage of Washington at the lectern, holding the court's attention with nothing but his voice, his facts, and his conviction. In courtrooms, classrooms, and conversations across America, the story becomes something more than a legal victory. It's a modern parable, proof that brilliance can emerge from unexpected places, and that preparation, perseverance, and courage can shatter the highest walls of skepticism. Denzel Washington didn't just win a case, he rewrote the assumptions about who belongs in the most prestigious legal arena in the country. And in doing so, he left behind a reminder that echoes far beyond the marble halls of the Supreme Court. In the end, it is not the title you hold, but the strength of your argument and the truth behind it that shapes history.